Senator from South
I
Dakota.
asked the senator from North Dakota if he could just yield for a question. You know, this is an issue which is important to both his state and my state for many reasons, not the least of which is we have, basically flooded 1.6 million acres of prime bottomland, some of the richest agricultural land in our states, in order to prevent flooding downstream. And then, of course, there was also stated other uses, various uses of the water that were to be allowed for the states that were impacted when this occurred. But I wonder if my colleague from North Dakota, he's already touched upon, I think, many of the reasons why this shouldn't happen, but he's a former governor of his state, and I know that our governor and our attorney general have made it abundantly clear that if the Corps moves forward, that they do intend to file a lawsuit, that they will litigate this. And as a former governor, if the now senator from North Dakota could respond to how his state of North Dakota might act in the event that this actually were implemented by the Corps, because it strikes me at least that this is without precedent. This is something that the Flood Control Act, which passed in 1944, and the dams were built subsequent to that now for the past 50 years, our states have had access to this water, and it's something that is a state right. There is no legal or there's no statutory, there's no historical precedent for doing this. And so I'm just wondering how the former governor of North Dakota might view this as a governor, as to what his action might be in the event the Corps of Engineers were to move forward with this, because it certainly would impact a lot of the industrial users, water users in the state, businesses, tribes. A lot of folks are going to be impacted if the Corps moves forward with this proposal. So tell me again, if the senator from North Dakota might, as a former governor, how he might view this and what he would intend to do, and what our governor and attorney general would intend to do in the event the Corps moved forward. Our attorney general wrote a letter to the Corps here, and this is one of the statements he made there. He said, "This proposal, whether disguised as a reallocation of surplus water, exceeds the Corps' regulatory authority and violates basic principles of federalism," end quote. And went on to lay out the reasons why our state would obviously enter into litigation if it comes to that, if it's necessary, in order to protect the rights of South Dakotans to the water that is rightfully theirs. And I guess I would be interested in knowing as well from the senator from North Dakota, if in fact during the course of the last many, many years, if his amendment would change anything, if his amendment would change anything that is happening today. In other words, today what happens if a state wants to use water in one of the mainstream dams, and there are 6 mainstream dams, there's one in Montana, a big one in North Dakota, and then we have 4 in South Dakota, all of which were created by the Flood Control Act or authorized there, dams built to protect from flooding downstream, and then also authorize various uses of that water. And I might just point out what some of those uses are. They were to be for enhanced navigation, cheap hydroelectric power, irrigation, programs to increase public recreation facilities, municipal industrial water supplies, and fish and wildlife populations. Those are some of the things that are stated that the water is to be used for. So the senator's amendment, which would prevent the Corps from charging for this water, as I understand it, doesn't change anything, the practice as it exists today, because a state, or a water user, I should say, would go and request an easement from the Corps, and then the state essentially would have to issue the water right. That's my understanding of how it works today, and under the senator from North Dakota's amendment, if it's passed, does any of that change? Mr. President, again, I want to welcome our other colleague from North Dakota, who also has experience as a litigator in protecting the interests of her state, and perhaps she could also comment on what action the states might take if the Corps moves forward. But I wanted to just point out to my colleagues, and I don't know, perhaps you already are aware of this, but I'm looking at some things that are proposed charges that the Corps would make under this proposal. And again, right now they haven't stated, I don't think, explicitly what that might be, but it ends up being a significant amount. In fact, Lewis and Clark Lake, which is Gavin's Point, or I should say Lewis and Clark Dam in South Dakota, they're talking about $174 per acre foot of yield from Lewis and Clark Lake. Well, as I said earlier, you're talking about businesses, individuals, tribes, industrial users who today have access to water that they believe, and I think we all believe, was something that was promised them when this legislation was passed way back in the 1940s, and that we have essentially now 70 years of precedent where it's been the case that the states have access to rightfully use that water for various purposes as authorized under the legislation, and that this would move away from that and now start to impose these fees, which I think over time could get to be quite excessive. Now, I appreciate the work that's been done by the senator from North Dakota, Senator Hoeven, in terms of trying to get the CBO to evaluate this in the proper context, and because for a while there they were talking about the scoring impact that was much larger than many of us believe it would have. But again, it's a hypothetical situation. It's not happening today. All you're simply doing is say we want to keep in place the rules of the game as they've applied to the mainstream dams now, mainstem dams for the past 50 years, 70 years since the authorization in the legislation that created them, but also since the dams were built. So I guess I would say to my colleagues from North Dakota, I appreciate their good work on this, and would simply reiterate, as a South Dakotan downstream from North Dakota, our states, and I think all the states in the Upper Basin, would be dramatically impacted by this, because it would be a precedent that is something that would be entirely new, something we haven't dealt with literally in all the time that we've had the dams, the lakes in our states, and again, at tremendous sacrifice in terms of the amount of prime bottom land that was given up when the dams were built and when the land was taken. So I guess I would defer to the former Attorney General of North Dakota, Senator Heitkamp, who's also joined us here on the floor, for some observations that she might have. And I would just say to both of my colleagues from North Dakota that that's an absolutely accurate observation. If you look at who's impacted by this, and we have one of our tribes, Standing Rock Sioux Tribe, of course, is partly in North Dakota, partly in South Dakota, so it crosses the state border. Cheyenne River Sioux Tribe, Lower Brule Sioux Tribe, Crow Creek Sioux Tribe, Yankton. We've got a whole bunch of reservations as you go right down that corridor, the Missouri River, that would be profoundly impacted by this. And like as we mentioned earlier, when this land was given up, when the dams were built, this was a lot of not only private land, but tribal-held land, which they gave up, and this would directly impact the access that they would have to water that is rightfully theirs. And so in addition to the concerns that our states have and our attorneys general have, we also have a lot of tribes that have a very vested interest in making sure that this doesn't happen. And that's why it's so important that our colleagues here support the Senator from North Dakota's amendment, because as was pointed out by Senator Heitkamp, this is a precedent-setting thing. If they can do this here, they may try and do it someplace else. And I also think that the point that was made by both of my colleagues from North Dakota, and this is a very practical consideration, it will cost the federal government and our states a lot more than what they're saying this is going to achieve in terms of revenues when this thing goes to court. And both the states and the federal government would be locked up, I would suspect, in litigation for some time, and the amount of revenue that would be raised by the fees that would be imposed under these various proposals that are being advanced by the Corps simply would pale in comparison, I think, to the litigation costs that would be involved with this. So that's a very practical consideration, and I concur, and I'm not a lawyer, and I certainly am not a former Attorney General or former Governor, and I know both of you have experience with these issues, but I can tell you from talking with our Governor and our Attorney General, they are highly confident that legally this is a very open and shut situation in case in which our states would prevail and be successful. So it seems sort of crazy in a way that we would have to even go down that trail, and I hope that we can prevent that from happening by having our colleagues join us today and support one final point of clarification, and perhaps the Senator from North Dakota could react or comment on this as well. And my understanding is that this, of course, this doesn't have any impact on the master manual, the way in which the Corps manages the reservoir. And so the degree to which there might be concern about, is this our water versus their water, that historically has plagued a lot of the discussions about the Missouri River upstream, downstream interests. As the Senator from North Dakota pointed out, the water gets used. The water is going to get used. This is water that's either stored or it's used. And I think it's a question of whether or not we're going to be charged. And the users of that water are going to be charged. And that does, of course, create a precedent. And if it's something that they can do here, The question is, what is the next state? Because this violates a principle of federalism, as was pointed out by the South Dakota Attorney General in his letter to the Corps of Engineers. But I just wanted to, for the record, for those who perhaps are viewing this as a battle, upstream, downstream battle, not the case at all. This does not impact the master manual, to my knowledge, and I would, if the Senator from North Dakota would care to react to that as well.